All right, folks, we are up and running. Thank you for your patience here tonight. We were waiting on the owl from the select board. It being 6:10 PM and a quorum having been reached, I will call to order the March 12th, 2024 meeting of the Charter Review Committee. All right, we will start with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Thank you, folks. I'm gonna suggest that we skip meeting minutes this week. We thank you to Michelle for working on everything. I know we got things out a little bit late, so we apologize for that. We'll come back in our next meeting. We'll do the minutes from March 5th and from this meeting. All right. Is there any public comment online? We don't have anyone in person. Mr. Donato, you appear to be the only member of the public here tonight. Is there anything you'd like to share with us? Weather in Fort Lauderdale, perhaps? All right, hearing and seeing no public comment, we will move right into our discussion items. We ended our last session talking about the moderator. Rob, whenever you're ready, if you could pull up chapter 2, section 6.
Give me a little bit. I'm pulling up the latest revisions. So if you people have paper copies there, work off of those for the time being, and then when I get this all squared away, then you'll see it up on the screen, please.
I can share the electronic version of the charter. Unless
Rob,
Michelle, you want.
I just sent it to Rob again, this just now, so the latest version.
Just give me a second.
Okay.
Let's see. Go with that.
It's nice to have some daylight while we're in this building.
Yeah. Boom. What's this top part?
It's now looking right at you.
I know, but so the top part is the camera.
Yeah, put it back. You're moving the room around.
Put it back and leave it alone.
Yes. Please and thank you.
We have an intermission. This is a.
Rob, if you're having trouble, oh, there you go.
There we go.
Never mind.
No, it was no trouble. It was just taking its sweet time.
Yeah, no worries. I was gonna say Michelle could pull it up in the time being, but since you've got it up, we don't need to. Section 6 covers the moderator, and while Rob gets to 2-6-1, I'll remind folks that we are not empowered as an appointed charter review committee to change the terms of office or the method of selection for members of the legislature. Our town council and I have discussed this and determined that the moderator would fall under this by nature of his tie-breaking vote in any town meeting session where vote results in a tie. I will say that I have that Kate and I also discussed 2-6-5, which covers the assistant moderator. It's unclear to us whether or not we can do something with that piece in terms of method of selection, in terms of office. We are concerned about it, and I'll explain that when we get to the section. So we've reached out to the municipal law division and the secretary in the Attorney General's office. Thank you. So pending a response from them, we can always come back and look at 2-6-5. But 2-6-1 says a moderator shall be elected at the regular town election for a term of 3 years. Again, I don't think we can change that, so I'd like to move on. Yes, Larry.
I think it's been so long since I've been here on this one meeting. Weren't we going to change it to annual? It says elections annual rather than regular, which doesn't have any meaning,
Yeah,
annual town election?
yeah, so I talked to Kate about this, she advised against doing anything with this section, so.
Okay.
I think from my perspective, anything that's not a special election would be the regular election. So because we are appointed, not elected, anything we do to modify this could be seen as a change in the term of office for the moderator. So we should stay away from that, I think. It works as it is. It's not great, but it works.
Right.
2-6-2 says the moderator shall have no vote unless the representative town meeting members present and voting are equally divided. Hearing and seeing nothing on that. 2-6-3 says the moderator shall preside at all representative town meeting sessions and shall perform such other duties as may from time to time be assigned to the office through bylaw or vote of the representative town meeting.
What are other?
Yes, sir, Mr. Lawler.
Thank you, Mr. Chairman. What are other duties?
Go ahead, Larry.
Appointment,
Hmm.
he does,
Appointment power for FinCom.
that's the major.
Does it later on say that he does appointments and stuff?
It says in the appointment set, various places like advisory, finance.
So why don't we wait? Why does that have to be in there?
Well, because it's a duty of the moderator to perform any duties that we assign. Go ahead, Alan.
Duties, is this someplace where we should, incorporate hybrid meetings or COVID-related meetings, or is that gonna be a whole different section that you'd like to do that?
Didn't we address this? We addressed it
Yep.
because in a previous section, it talked about town meeting members sitting in a section. We expanded that to be either in person or
But do we specifically give the moderator any duties, how we would run a hybrid or schedule a hybrid with the select board in advance, the kind of things he's done so far in the last 2-3 years?
no, I think that would fall under the general laws, the procedures just defined by the law.
Okay, very good, thank you.
I will say this, though, it could be superfluous for us to say the moderator shall preside, that's in the general law. So we don't need that piece, it could also be superfluous to say they'll perform other duties as assigned, because we can still assign duties and he still has to do them. Good.
There is a value to indicating that duties can be assigned versus, in some instances, you always have the issue as to who can assign a duty to an elected official, what their scope of their responsibility is. And you certainly don't want to be saying, oh, well, if town meeting wants to assign a duty to the planning board. No, I'm sorry, you just can't do that. They're two separate bodies and we have to be clear that that's the case. So I think it probably makes sense to indicate if the moderator can be assigned duties, who can assign duties to the moderator?
And if I may, that brings up. The moderator exists under Mass General Law.
Mhm.
And I think that what Steve said about the planning board is also true about the moderator. I mean, the town meeting can say to the moderator that he has to referee football games or whatever. And the moderator can say, not so much.
Yeah.
So it's gonna take time, but that your statement that some of it is superfluous, the whole thing is superfluous. The entire section, whether town council is going to have difficulty with our removing it. I mean, he presides at representative town meeting because state law says that's the job of the moderator. And he does what he does what he's told to do, and I don't think the charter can expand that because he's an elected official.
Right.
With that in mind, just And I'm channeling my inner Joe Hutchinson right now, indicating that if Joe were here, he would be very upset if we took anything out that didn't explain at least why we have a moderator. And so I don't have a problem with leaving in the section that just says the moderator shall preside at all representative town meeting sessions. But maybe delete the remainder as being not only superfluous, but technically incorrect.
I leave it to the pleasure of the committee to make a motion.
I make that motion.
I second it.
So Mr. Bulletin motions that we delete from section 2-6-3 the words starting at and shall perform.
Yeah.
To the end of the sentence.
Yep.
Seconded by Mr. Lawler. Is there further discussion? Hearing and seeing none, I will call the roll. I'll note at the top of this that we have enough members absent for Mr. Bulletin and Mr. Hammond to serve as full voting members. So when I call the roll, their votes will count towards the final count. Mr. Bulletin, your vote?
Yes.
Mr. Hamlin?
Yes.
Ms. Cavaco is not present. Mr. Costello?
Yes.
Mr. Hutchinson is not present. Mr. Lawler?
Yes.
Mr. Levin is not present. Mr. Pizer?
Yes.
Ms. Votrain is not present. Mr. Zubaroli?
No,
And I vote yes, in a vote of 6 in favor and 1 against, the motion carries. Excellent. 2-6-4 reads, following the raise, sorry?
that was me. The editing wasn't behaving itself, so I said, uh-oh.
But we heard the uh-oh, we just wanted to make sure that we understood what it referred to.
Yeah, the editing wasn't behaving, so
Okay.
I was like,
I like these more intimate meetings, by the way.
No.
Jeez.
2-6-4 reads, following the raising of a point of order at any town meeting, a motion to appeal the ruling on any such point, on such point of order shall be allowed by the moderator and shall be decided by a 2/3 vote of the town meeting.
Dave, what was the vote on
It
that?
was 6 in favor and 1 against.
We're not allowed to change any of that. Any of this right now, right?
2-6-4? We sure can.
That one.
Yeah.
That's a fairly new addition, right? That was the last town.
Yeah, I like this rule. I'd like to see it stay as a town meeting member.
It's actually worked once, it's a very important time.
Mr. Lawler,
Would decided by a majority vote be in line?
Larry, you're a town meeting member, Alan, you're a town meeting member.
I like the high bar of 2/3, to be honest with you, to go, against the moderator, whoever happens to be. But I would have no objection if somebody said majority.
Well, there is a, I mean, there's a balance. We have had a rather efficient town meeting. And there's a balance between efficiency and, democracy is the wrong word, but, taking a lot longer time. And it seems to me that the issue of a point of order, the moderator is responsible for running town meeting. If he's going to be overruled, it seems to me it should be an egregious situation.
I would agree. Mike, you're a town meeting member as well. Mrs. Zubaroli, your hands up first, I'll give you the floor.
I was just gonna say that, in order for the moderator to be overruled at any point in time, it should be for something serious, and a simple majority just doesn't make it serious enough. I would be opposed to changing, the language from 2/3 to anything other than what it is.
Mike, do you have anything on that?
I'm okay with it the way it is.
All right. Go ahead, Larry.
Just being a pain in the.
We can do this without a vote. Put the dash in between 2.
Thank you.
Please and thank you. I'll do that without objection. Thank you. All right, so 2-6-5 is about the assistant town moderator. So I'll just, instead of reading the whole thing, I'll preface it by saying, sharing with you folks the conversation that Kate and I have had. The way that the section reads at this point is that the assistant town moderator is appointed after the election, but does not take office until the following town meeting. Now, that town meeting could be a special in the summer, or it could be as late as the October town meeting. And so, our concern is that, our current, assistant moderator, Nicole, does a lot of work in the lead up to town meeting. But technically her term in office has not started, and technically the assistant moderator is appointed every single year. So Kate and I would like to be able to adjust this, but we don't know if we have the authority to do so. The conversation that we had is essentially, well, in the absence of the moderator, the assistant town moderator swings in and serves. So the contention between us is that my opinion is that in those cases, the assistant town moderator ceases to be the assistant town moderator in that moment and becomes either the acting, or in the event of the death or disability of the moderator, the moderator. So I think that we could make some adjustments to this. Kate is unsure. That's why we've gone to the municipal law division. Once we get a decision, we can come back and debate this piece.
I don't think the assistant moderator becomes the moderator if the moderator
It
is.
says it.
I know it's, is absent from a town meeting, but if you're talking about in absence. If the moderator is no longer the moderator,
Yep.
If the moderator becomes disabled or passes away or
yeah,
moves out of town and is no longer eligible.
is that clear that the assistant?
No, it's not clear. That's where our concern rests, but we wanna make sure we can make adjustments to this.
Because I mean, state law says that town meeting elects,
It actually says the clerk becomes,
right,
so that,
but then the clerk holds an election.
yes.
Um,
So there are a lot of layers as to what is wrong with this particular part of the section, so that's why we want to get clarity on it before we spend too much time discussing that.
Is it your suggestion or town council's suggestion that the assistant would move into the moderator's position? Or is that what you hope to achieve?
No, so we actually think that in the way that this is written now, that is what would happen, but we believe that it actually should be the town clerk who takes over, and then as Larry has described, there's a process for.
Unless I'm missing the point, it sort of reminds us, we've talked about this on a couple of occasions where you then have an appointed person take an elected position.
Right,
Which will sort of knock down a few times prior.
yes, agreed, that's why we want to be able to make changes to this, we just don't know that we can at this point in time.
All right.
So I think that the problem is that whoever wrote this modified the moderator power by saying that it had to be accepted by town meeting.
Yeah.
So during that period between the election of the moderator and town meeting, one would think that the moderator could have the power to appoint somebody, and the check would come into place at town meeting.
Right.
So, I mean, assuming that we decide that we're going to improve this section, it seems to me that would be the model that we would want to achieve.
Yeah, I mean, there's a number of ways that we can skin this cat, but I don't want to spend too much time talking about it because we don't know what we can do at this point in time. So my suggestion is that we come back.
Okay.
2-6-6 says the town manager shall provide support personnel to assist the moderator in carrying out the moderator's assigned duties. I don't think we should do anything with that. Hearing and seeing no changes, we've concluded our review of the moderator. 20 minutes, that's record time for us to get through a section. All right, let's head down to section 10. Section 10 covers the conflict of interest provisions of the charter. So we had lengthy debates about this earlier in the process. I did promise that we would come back to this at a later time. And I know that there are several folks who have asked to speak on this. So, Mr. Hanlon, I'll give you the floor. Mr. Bolton, I'll come to you next, and then obviously anyone else who wants to speak. I will give them license to do so. So, Mr. Hanlon, the floor is yours.
Okay, thank you. Just a heads up, I'm having computer issues. My computer is basically dead. So I'm having to do this on my cell phone. I'm not even sure if you can see me.
We're seeing the section, but if you'd like us to see you, I can pull you on over.
That's okay. Not a problem.
We hear you
At the
loud and
same-
clear, though.
Okay. So I've talked to David a little bit about this. I was the chair. Let me start this way. I was the vice chair, excuse me, of the Conflict of Interest Subcommittee 10 years ago.
I think we lost you, Mike.
Costello served on the committee along with 10 other people. I forget whatever it was. Our job was to review this clause in our charter, the conflict of interest clause, and make recommendations to the committee of precinct chairs and ultimately the town meeting. So we did that. I was in favor of putting some sort of enforcement provision into our charter, into this section of the charter. That was not a widely held or popular position. The precinct chairs made it very clear that they were not in favor of enforcement provisions, and nor was ultimately town meeting in favor of enforcement provisions. So we debated and discussed this thing for months and months. We talked to the Ethics Commission, and at the end of the day, no changes were made to this provision of the charter, the conflict of interest provision. So at this point, it's 25 years old. It was written, I believe, I'm fair and say, it was by Bill Abbott 25 years ago in some either a charter commission or a charter committee, and it's been there for 25 years. The debate always at this point seems to be, are we going to keep it? Are we going to scrap it? Or are we going to amend it? I am not in favor of scrapping it. I think it provides a valuable, not service, but I'm searching for a word. I think we should keep it in the charter. I'm not in favor of scrapping it. I do think that the language around town employees is problematic. It's problematic from the point of view of it just puts a big spotlight on town employees that I think is not necessary. I remember, maybe Alan remembers this as well, Mr. Abbott coming before our subcommittee and suggesting, this is my recollection, it's 10 years old, that the reason they put this in place to begin with is because of perceived conflict of interest by town employees voting in their own self-interest. So we have the clause, it's there. When this issue comes up at town meeting, I want to get this on the table. There are several town meeting members who consistently suggest that town meeting members are exempt from the conflict of interest statute. and they are technically correct. If you look at chapter 268A, section 1G, town meeting members are exempt from the definition of municipal employees. Town meeting members are exempt from the definition of town employees. So all town employees, all elected officials, all appointed committee members are subject to the conflict of interest clause. But town employees, in their capacity as a town meeting member, are exempt. That's section 1 of chapter 268A. If you read section 23E of chapter 268A, it suggests quite clear, well, it's not actually clear, but the Ethics Commission has clarified this, that towns can impose a higher standard than that standard imposed by the conflict of interest statute. And we have done exactly that with our conflict of interest clause. So if anybody has any questions about that, I sent David very late today a copy of a letter from the Ethics Commission dated October 10th, 2014, where Mr. David Wilson, who's an attorney with, or he was at that time, 10 years ago, wrote a letter addressing to Dale Weber, clarifying that whole issue. So I am in favor at this point of amending the town charter to take out the words town employees. And unfortunately, I did not bring that. I didn't bring my hard copy with me, but I guess I can see it on the screen. So
I can help you craft a motion, Mike. I do want to say, I think you summarized the letter that you shared with me very succinctly. You're right on point with the information as shared at the time from the Attorney General's office. In terms of what constitutes a conflict of interest, the exemption provided to town meeting members as they act in their role as town meeting members, including when they are a municipal employee. I think that you also covered pretty well the addition of a higher standard being allowed at the municipal level. I do want to note, Michelle has sent me from the Charter Review Committee in 2017, 2018. There were 2 motions made concerning this section. The first was to add a requirement for town meeting members to participate in the conflict of interest law training program provided online by the State Ethics Commission. That failed by a vote of 92 in opposition and 30 in favor. A second motion was made for the town moderator to provide a brief review of the charter's conflict of interest section at the top of every town meeting. That too failed in a vote of 60 in favor and 63 in opposition. Town meeting has, I think, consistently been uninterested in imposing further conflict of interest provisions upon itself. Mr. Pizer, I know that you're in favor of scrapping the whole section, or you were at one point anyways. I'm gonna ask, just by show of hands, this is not an official vote. Is there, if folks could raise their hands if they think we ought to scrap the entire section? All right, Mr. Pizer is the only person to have raised his hand in that unofficial poll. So the other thing so Mike, we're definitely gonna keep it. So your first request there is met. The second request you made was that we consider the removal of employees from the first section here, which we can discuss in a moment. Mr. Lawler, I saw you raise your hand.
Two things. Did you say that town meeting had no appetite consistently to touch this at all?
In the past, yeah, and Alan and Larry and Mike, you folks can speak to that. Alan,
Yes.
do you want to?
Yeah, like I remember a lot, exactly like Mike does, Mike Hannon. We had marathon COPC meetings back in the 14. We had a 2-year stint where we tried to work on this language. We had a very contentious, I believe, town meeting vote where there were very clear sides, and everyone got their opportunity to speak. And at the end of the day, we kept the very same language, and everybody went away not so, not so thrilled, but happy that it didn't get changed. And it was still in play. And you could still make the argument that it didn't impact members if you didn't bring in the second part of the state code that allows a town to make some provisions.
Yeah, the other thing I'll add to that is that the Ethics Commission has opined that they won't be enforcing any ethics complaints anyways.
And they were like that back then, and then there was never an enforcement mechanism or a penalty mechanism that anyone could even, I mean, $300 an infraction. If you're gonna make $10,000 raise in your salary, $300 is easy way to do it. So there's really no way to handle it with a penalty. The honor system and the ballot box has been the standard answer. And you have to hope that that's how it works.
Rob, I see your hand up and then I'll come to Tim.
There. Actually, my question's for Larry, because I remember when the commissioners debated this section, they spent a lot of time debating on this section too. And I know, Larry, one of the things that you're helping us with is to provide some context from the commission to this committee. So when you all discussed it as a commission, what did you discuss?
Pretty much the same, pretty much the same discussion that we're having came up to pretty much the same conclusion that bad enough the way it is, don't make it worse.
Okay.
I mean, the problem, if I may, the problem that the commission saw, or at least part of the commission, is that the way it's written, it's advisory. And I suppose if it's advisory, it's advisory. And the idea that you can take an elective office and impose penalties on that elective office is pretty serious. And the end point of the commission, I suspect, of the committee is that's a bridge too far.
Yeah, I think the other piece that Mike brought up is the enforcement mechanism, and I think that if we were to put some kind of enforcement mechanism in, Alan mentioned, a monetary fine. I don't think town meeting would go for that. And I also don't want to impose that on folks. Everyone's a volunteer on that, on town meeting. So I'm not sure that that's an appropriate outcome for folks who are in contravention of this section. But if we're gonna have it, we probably should have some kind of enforcement. Whether that's through the COPC and we empower them to do nothing more than send public censure of the member. And let voters then decide what they want to do with that. I don't know,
I also think I was just gonna say, I also think it's important enough to think about size and scale. I think, I mean, my numbers are probably off, but we're talking about 17, 18 people who are employees of the town who are also town meeting members. Is that, if they vote as a block, say, I mean, is that really going to influence the whole vote of town meeting? I mean, that's just,
Yeah, I mean, I guess it depends on which side of the vote they're on.
this is true, I mean, yeah, this is true, but it's just, I mean, I think that that number is, that scale is also something to think about as well.
Tim?
It's actually a follow-up from the question that I asked you. If the town doesn't have an appetite and has been consistent with that, is there a way we could just move past this and just, so I'd like to, suggest that we move ahead and accept the language that's already right here.
Yeah, and that's fair. I think, Mike probably wants us to address the piece by, removing, the employees. But I did promise Mr. Bulletin that I'd give him the floor, so let's give Steve the floor and then see where we go from there.
Okay.
First, just for the record, as it were, I think that we should be doing more when it comes to ethics in town government overall. It's not unique to town meeting. We need to make sure that our government is transparent as possible. That's something that I noted everybody in the room said. So, town meeting, in my personal opinion, should be more transparent in what it does. We are seeing a great proliferation of town meeting members as we add to this in different professions which have the potential for conflict. Professions which those people are already familiar with ethics rules. Attorneys, accountants, financial professionals, realtors, engineers, architects, construction people. They all are familiar with their ethical requirements. To add an ethical requirement on top of that is hardly inappropriate, especially where they know they shouldn't be doing something. I think that we should be looking at the possibility that town meeting can be influenced, not in the, Rob, you're absolutely correct. I don't think you're going to see influence in terms of blocks of people. I don't think that's the case. But I think you do see individual members who can be influenced to represent a client's interest or and basically be and I don't want to imply that there's anything untoward about it or illegal. No one's being bribed to do anything. But in essence, they're being paid as advocates for their clients as town meeting members. I just don't think that's right. I don't think it's right that an attorney gets paid to do something, or a realtor says, oh, is told, oh, you're gonna get this, if you get this thing changed, I'll give you the contract. Or if I get this zoning changed, I'm gonna give this builder the development rights. I just don't like to see that. I think that should be prevented. I don't know that it's happening all the time. But the fact that I've seen it happen on a rare occasion, to my knowledge. Again, I don't know everybody in town meeting. I don't know what their relationships are. But I do know there are instances. And I don't think it's right. That said, and I've drafted something that I think we can address, but that said, I don't think it's going to go anywhere. I understand that. I understand if we put this forward, town meeting will look at us and go, no, I don't want any more obligations. I don't think we should stop because of that, but I recognize that there's also no value to truly banging your head against a wall either. So I just wanted to be on record to say that I think we should be doing more.
Do you want to summarize for us what you've drafted?
I drafted a provision very similar to what we have. I reorganized things a little bit where I created it where it says essentially that no member of town meeting can, and I use the ethics rules, you not only not vote, because this is only limited to voting, but actually participate in the discussion. If you're gonna recuse yourself from something, you're not supposed to be there advocating for it, and that's another issue. Even if someone's done, I'm gonna recuse myself, I'm not gonna vote, that's great. But I'm gonna stand up and tell everybody why this is such a wonderful article. That's inconsistent, but nonetheless, so that they should be discussing or voting on an article in which they or any immediate family member or any business or organization, I just defined it as entity, in which they're involved, or on behalf of a client whom they have served, in the client or customer whom they have served in the past 12 months. And I've defined those terms, so it identifies as client or customer as somebody with an individual or entity for whom professional services have been provided in the past 12 months. And I defined professional services to make it clear that professional services has to do with people who are licensed under state or federal law, with the exceptions of some of the standard, beauticians and cosmetologists are licensed. You exclude those things. I also excluded medical, therapeutic, educational, the types of things. I tried to limit to those people who would basically be involved in the types of things that could be influenced here, whether that's zoning, real estate, purchases, things like that. Again, think about a realtor who's getting a commission on a sale to the CPC. It shouldn't happen, but there's nothing in our charter that prevents that. So that's basically what I did. As far as an enforcement mechanism, I'm with Alan in the sense that I don't see a fine or monetary sanction as being an appropriate thing. But I think that, again, given that I tried to really narrow this to those types of circumstances, which would be egregious. I think if you're engaging in something that you as a professional know you shouldn't be doing, as a professional, as a town meeting member, I can get away with it anyway. I think if you do that, there should be a sanction, and the sanction should be a severe one. And I think the sanction should be that you are now precluded, you are no longer eligible to run for town meeting the next cycle.
Who decides?
We would have to make we would designate a body that exists.
Designate a body to do it. I get it, I know, it's not fun. But if you're not going to.
I don't disagree with you, but we're having trouble fielding 9 people from each precinct today. And
Yeah, but we should still at least do something.
I agree with you, you should do
Yeah,
something.
we know that it's not gonna go anywhere, but isn't it a
But-
moral
But
commitment to do something?
the argument that we can't get qualified people is not an argument as to.
I understand that's a whole separate problem, but if you start sanctioning people and eliminating them from participating for a year,
But if they did
I don't
something,
disagree that if someone does something egregious, I would like to see that happen. I just don't know if it'll play.
I tend to agree with you, and that's the point. So I started this for the preface by saying I wanted to be on record as having said, this is what I favor. But at the same time, I'm also not one to waste everybody's time with, I mean, I wasted my time preparing. I don't need to waste everybody else's time reviewing it if it's not gonna go anywhere.
I'll take the temperature of the room in a minute. I see Mike has a hand up and then I'll come to you, Larry.
My turn?
Yep, go ahead, Mike.
Okay. So we are talking about the legislative branch of government. And just to put this in context, the federal constitution provides, and federal law provides sanctions for federal, representatives and senators who break their code of ethics. And we saw that happen recently with the guy from New York, the representative from New York. He was removed. In Massachusetts, our constitution and our laws and regulations provide sanctions for state reps and state senators if they violate their code of ethics. But so now we get, and that's the legislative branch. Robert's Rules of Order provides a sanction, it's called censure. And actually, they do talk about it going beyond censure to removal. Censure is nothing more than a slap on the wrist, but it's covered in Robert's Rules of Order. Now, town meeting is not governed by Robert's Rules of Order. It's covered by town meeting time. And town meeting time addresses the issue of conflict, but it does not provide any means for sanction. And so we're back to the real issue is that town meeting has no appetite for sanctions. And in part because there's no logical person or organization to enforce the sanctions, enforce the code of ethics. And somebody said we'd have to, well, it's actually in town meeting and town meeting time, that you would have to create a bylaw in order to do that. That's not something we can do, and it's not something the town meeting can do. So nobody, we looked at what other towns in the Commonwealth do. I believe there were 4 other towns that had a conflict of interest provisions, but they're all advisory. There are no sanctions provided in any of those other communities. Mm-hmm. So with regard to, I want to go back to the issue of town employees in that first paragraph, 2-10-1. My feeling is that town employees should be, in their capacity as a town meeting member, should be bound by this clause, this conflict of interest clause in our charter. But I think the language puts a spotlight on them that is unnecessary. And in some cases, I think it offends certain town employees who are also town meeting members. You know, whether they agree with whether this is a legal provision or not, as far as I'm concerned, it is. That shouldn't even be debated or discussed. But my point to this group is that we could amend this provision to remove the words town employee if you have the appetite for it. If you don't, then I'm fine with leaving it alone.
Yeah, let me do this first.
Section 1 wouldn't make sense though without.
Yeah, so we'll come to that. So if you could just raise your hands if you think that we should provide that if we should make the conflict of interest section more stringent, meaning impose a greater conflict of interest on town meeting members.
Are you saying except Steve's?
We'll come to Steve's if the group is interested in pursuing that. So if you think we should pursue a more stringent conflict of interest provision, please raise your hand.
Yeah, morally, yes, practically, no.
Yes,
So
we're in a moral quandary where we believe that we should do this. But we also don't believe it will result in any positive outcome. So the next question is, ought we to strike 2-10-1? So Mike, what I would say is, so 2-10-1 only covers town employees. So we wouldn't simply remove the word town employees. We would strike that section, and then we would cover town employees under 2-10-2 and the remainder of the section. Would you want to make that motion, Mike?
Just to strike the entirety of 2-10-1?
Yeah, because to Steve's point, if we took out the words town employees, it covers no one, because that section is solely about town employees. So I think what we would do is we would strike 2-10-1 and then perhaps make some clarifications in 2-10-2.
I don't necessarily agree with that concept, but I can't see it on my screen because
Does it actually say town employees?
Yeah, so,
It says employed by the
Well,
town,
yeah.
right?
yeah, so
Yeah.
if you could scroll back up, Rob, I'll read the entirety of 2-10-1 so that we're all on the
Well,
same page. Notwithstanding any general or special law to the contrary, any representative town meeting member who also holds a position of employment by the town shall be prohibited from voting on any town meeting article in which such employee or such employee's department has a financial interest. Such representative town meeting member shall notify the town clerk in writing prior to the representative town meeting session or during such session at such times as such member becomes so aware as to any articles giving rise to such financial interests. This section shall apply to the annual budget article or any later amendment thereto as follows. The representative town meeting member is prohibited from voting on the budget line item for his or her department or agency, but shall not be prohibited from voting on any other line item or from voting on the overall budget appropriation. So that whole section only applies to town employees.
Point of information?
Yeah.
Chair. My experience as a town meeting member, you don't vote on line items.
Yes.
So is there any practical purpose beyond?
I think this is just simply targeting town employees. I don't think I think there's animus behind this, is how I feel about it.
I agree.
So, Mike, where do you stand now?
I had a different thought.
Go
And
ahead.
I can see the that paragraph right in front of me on the screen here. So I will actually make this in the form of a motion. That's starting with the words in the second line. It says my copy or on the screen, it says line 383. Strike the word, starting with the word who also holds a position of employment by the town. So strike who also holds a position of employment by the town. And then go down to the next line. And strike employees or such employees department. And add any town meeting article in which
Mike, I think what you're doing, Mike, is doing exactly what I said. I don't think that we need, I think we need to strike this section and then go to 2-10-2 and review that. I think that we need to add perhaps in line 393, where it says in which an immediate family member, I think we need to say in which they or an immediate family member. And then we can go from there.
Yeah.
The place I'm trying to get to, David, is very simple. It just makes a simple statement that town meeting members who have a conflict shall abstain.
That's 2-10-2.
Yeah, so I'm gonna ask that someone makes a motion to strike 2-10-1 in its entirety. Larry makes the motion.
I'll second.
And Steve seconds. Larry, I skipped you during our last round of discussion. Would you like to discuss this item any further?
Not at this point.
All right. Is there any further discussion on the matter? Excellent.
Dave.
Hearing and seeing that. Oh, go ahead, Rob.
Thanks. I couldn't get to the digital hand fast enough.
No worries.
If town meeting has no appetite to change this, and if we're apathetic at best to change this, and it's been tried before, then why are we spending the time and energy to talk about this? This just, it doesn't seem productive.
Yeah, I hear you, Rob. I think they might be open to this because what I see in this section is it's creating two classes of town meeting members. So they may be willing to equalize the playing field. Truthfully, in effect, the work that we're about to do by striking this and then adding additional language to 2-10-2 honestly changes nothing. It's simply cleaning it up and taking the target off the back of town meeting members who are also employed by the town. Any further discussion?
Nope.
Hearing and seeing none, I'll call the roll. I just heard someone pipe up. Go ahead, Mike.
Okay, one last comment before we vote on this.
Yeah.
Part of my goal, or part of my thinking on this subject, is that many town meeting members, most of them don't say anything, but the ones who are the most outspoken refuse. Look at this, David, you didn't share this letter with people, or did you have the chance to do that?
No, I didn't. I'm sorry.
Okay, think about Larry Pizer, you've been there, Alan's been there, any town meeting member's been there when Mr. Weber, Mr. Kelly, whatever, stands up in front of town meeting and said, town meeting members are exempt from the conflict of interest statute. And they totally ignore, right here in black and white, in a letter addressed to Mr. Weber, Dale Weber, October 10th, 2014, in black and white, from David Wilson, the lawyer for the Ethics Commission, says, yes, town meeting members are exempt from the conflict of interest statute. I got it. And towns can impose a higher standard. My whole point is, I want to get over this hurdle with town employees so that they will stop beating their gums on this issue and accept the fact that the whole point of our conflict of interest clause is to bring town employees, not town employees, but town meeting members under the conflict of interest provisions.
The same as anyone's.
That's my goal.
I think we're gonna accomplish that, Mike. Mr. Lawler?
Can we move the question? Please?
Yes, we can move the question. Mr. Bulletin, your vote.
Yes.
Mr. Hanlon?
I'm going to vote no.
Okay. Ms. Cavaco is not present. Mr. Costello?
No.
Mr. Hutchinson is not present. Mr. Pizer?
Yes.
Oh, I skipped Mr. Lawler as well. Mr. Lawler, your vote?
Yes.
Mr. Levin is not present. Ms. Votran is not present. Mr. Zuccaroli?
No.
And I vote yes. In a vote of 4 in favor and 3 against, the motion passes. I think under 2-10-2, I'll wait until you've stricken that, Rob, to move on. I think the only thing that we need to do is add the word they in advance of an immediate. I think we would add the words in which they or an immediate family member or any business or organization and so on and so forth. To make it clear that the town meeting member also has to be party to the conflict of interest. Thoughts?
You have to, because you're 2-10-2 doesn't impact the town meeting member at this time.
Right. I don't think. I'm happy.
I think, well, it's too late now because it's been voted. We should have put a comma or two in 2-10-1 and put the change there, in my opinion, but right now, all you're worried about is family and spouses and things like that now.
So let's go through 2-10-2. So notwithstanding any general or special law to the contrary, no representative town meeting member shall vote on any town meeting article in which an immediate family member or any business or organization in which the representative town meeting member serves as an officer, director, partner, or employee has a financial interest. For the purposes of this section, immediate family member shall be defined as the representative town meeting member, his or her spouse, and each of their parents, children, brothers, and sisters. Any such representative town meeting member shall notify the town clerk in writing prior to the representative town meeting session as to any articles giving rise to such financial interest. I actually think we're covered.
You okay with that?
Anyone have anything?
Al?
Mike, how do you feel with that?
So,
I apologize, I didn't see that sentence, that does appear to cover, that's all
Yeah.
fine.
Mike, go ahead.
so David, if I get your gist, you're suggesting that the language of 2-10-2 already covers town meeting members generically, all of them, whether they're town
Yeah.
employees or not.
Yeah, and I'm getting a lot of people nodding their heads in the room.
Well, where is it, what line, but it's clear,
396.
396 to 397.
Yeah, 396 says that immediate family member is defined as any representative town meeting member, and then it goes on to describe the other family members. So now we're saying all town meeting members, regardless of whether or not their employees are held to the same standard.
All right, can I just ask that Rob scroll back to the beginning of this section? The first
Sure,
sentence, I want to see the first sentence. There you go. So I'm being a stickler, I guess, for the language. In the second sentence, all right, not the second, the line 393.
Yeah.
Would it make any sense to add the words representative town meeting member before in that line before immediate family member, so that you include them in the list?
Yeah, I mean, we can, it's superfluous because they are encompassed under the definition of immediate family member. I think it's cleaner, so if folks are okay with a housekeeping vote, I'd like to ask for a motion to amend line 393 to include the words after in which, and to include the words a representative town meeting member or,
So moved.
hold on, I'm not done.
Oh, sorry.
Did you get that, Rob?
Say it again.
So after the word which in line 393, you would write the words the representative town meeting member.
Hold on. Go on. What else?
It's not showing up on our end.
I know, I'm writing it. I haven't typed it yet. So just you tell me the whole thing and then I'll type it all in.
I'm gonna jump around in sections, so can you type it in, please? So after the word which, we would say the representative town meeting member. Or. And then down to line 397. You'll strike the words the representative town meeting member. Well, actually, no, don't do that.
No, I would leave it in there.
Hold on,
Town meeting member apostrophe S.
yeah, you do, you turn member into the word members with apostrophe S. And then strike the comma, his or her.
Why is it an apostrophe?
Yep, we'll get to it. Strike the words his or her.
Okay.
All right, so now this would read, if you want to scroll back up, Rob. So the motion would be to amend 2-10-2 to say, notwithstanding any general or special law to the contrary, no representative town meeting member shall vote on any town meeting article in which the representative town meeting member or an immediate family member or any business or organization in which the representative town meeting member serves as an officer, director, partner, or employee, or has a financial interest. For the purposes of this section, immediate family member shall be defined as the representative town meeting member's spouse and each of their parents, children, brothers and sisters, and so forth. Will someone make the motion? And then we'll do.
Motion.
Moved by
I'll
Mr.
make the
Lawler.
motion.
Mr. Lawler made the motion. Mike, will you second?
Yep,
Mr. Hanlon seconds the motion. Larry?
If we've eliminated the description of not that if we're not gonna enforce it, I don't care, but if we've eliminated the description of financial interest,
It's the next one.
Next section.
Section 2-10-3 defines financial interest.
no. Well, okay, if that's how you wanna do it, because the big problem historically for this section has been how big, at what point does the financial interest impose itself? Look, the budget is $300 million. The town clerk's salary is part of the $300 million. If the town clerk is a town meeting representative, which town clerk isn't, but whatever, can that person vote on the entire budget? Is it the budget of the group within which the town, is it only the salary line in which, and that was never, enforcement was based on the fact that was never made clear. If we're going to say the interpretation financial interest by the State Ethics Commission, I don't think we've achieved any clarity, but that's, when I suppose we're no worse off than we were before.
Steve?
Forgive me, Mr. Pizer, but what enforcement?
Exactly.
You've made the point that this is advisory, that there's nothing to be done. So what we're trying to do, as our chair has said, is take the target off the back, municipal employees, and say, everybody's got to follow the conflict of interest laws, address what constitutes a financial interest. And I would argue, based upon my reading, though, I can even cite the last case that I read that talked about what constitutes a financial interest. A town meeting member who is a town employee voting on a budget line item for themselves would constitute a financial interest. So technically, it would fall under there. That's a big technicality because there will be absolutely nobody whatsoever there to enforce this. And it will sound absolutely lovely. Town meeting will vote against it and we will go on merrily in our way with our heads in the sand.
Yeah, and the Ethics Commission and the Attorney General's office both said that if you're acting in your capacity as a town meeting member and not in your capacity as a municipal employee, then you're exempt. So, I mean, we're in the circle now. Like,
Okay.
we're just going round and round and round. Like,
I'm only concerned, one of my friends, whom I usually admire, was talking about negatively about town meeting members testifying. I'm horrified at the concept of talking negatively about town meeting members testifying. That's what town meeting members should be doing. And I don't have to listen if I don't agree with that town meeting member, but I certainly want to know what that person thinks. I'm only concerned that someone might say something negative about a town employee. I suppose we would just have to I'll back off because I suppose we'll just have to say that they go read the Ethics Commission and talk to the Ethics Commission. They won't give any advice anyway, because they don't believe in, that they're responsible for sanctioning town meeting members.
It's the dog chasing its tail.
Fine,
It's-
sorry.
That's
Can
fine.
I,
Yeah,
Go ahead,
David,
Mike.
could I add something?
Go ahead.
I want to put my thoughts on this subject in context. I believe this happened when I was serving on the Finance Committee. There was an article to accept a firefighter contract. And that article became quite contentious at the Finance Committee. There was a lot of discussion and debate about it. And we made a vote to not accept it. And then that vote was reversed at a subsequent meeting to accept it and support it. And it came to town meeting. And there were several firefighters who were town meeting members. And they were quite vocal about their support for this contract. And they voted in favor of the contract. That offends me personally. Now, voting on a budget line item that's got their salary in it, or the town clerk sitting as a town meeting member, voting on this town budget with his salary in the town budget, doesn't bother me at all. That's ridiculous. But a union member, town employee, town meeting member, voting on their own employment contract, that bothers me. I think that's a conflict. That's where I'm coming from. So you got to keep this, what is the definition of financial interest in context? Now, the Ethics Commission has their rules and we can't change those rules. But I'm just trying to put it in context the way I see it. Thank you.
Steve. Thanks, Mike. I'll go Steve and Rob.
I'll just address what Mike said, which is, yes, Mike, it is offensive that they do that. They shouldn't be doing that. And under what we have had in place and what we have currently, they shouldn't do it and they can't do it. And just as it offends me that a town meeting member would vote on a real estate transaction or a construction article or something else where they have a personal financial interest, that offends me too. And they shouldn't do that based upon these types of things. But you know what? Unless we're actually gonna put some teeth into this, it doesn't really make a difference. So I think the point of this was to essentially show municipal employees and town meeting members generally that our belief is that all town meeting members should be treated equally. In this case, equally benignly, equally negatively, equally meaninglessly, but nonetheless equally. But that's what it is. It's equal nonsense as opposed to giving one of them specific nonsense. But at least we're setting a tenor, if nothing, if rather, maybe it's form over substance, but at least we're setting some sort of a message.
This conversation feels like we've defeated ourselves. Rob, I see your hands up.
Thanks. I just, Steve, I think I think you have some good points in what you in what you say. I kind of feel like, and this conversation, not this conversation, but this conversation comes up all the time. And, Mike, if we're going to look at what you said, as far as people voting on their contracts, then we would probably need to start listing the employment groups in the town, because with the exception of administration, they're all union employees. And I'm also concerned about the idea that, if we start going down that road, then, we pick up an ancient argument that, town employees are hacks. And I don't want any appearance of that at all because, you know, being the son of two town employees, they're not. Being a municipal employee myself, I'm not. And, you know, anything that smacks at that language, that is something that I would find offensive. So, you know, honestly, I think it's just best that we leave this alone.
Thanks, Rob. Mr. Waller?
We move the question. I was gonna show my admiration for you by saying exactly that.
Yes, we can move the question.
And could you, the question is to change,
Yeah,
yeah, fine.
the question is to amend section 2-10-2 as
Okay.
displayed on the screen. Mr. Bolton?
Yes.
Oops, Mr. Hanlon?
Yes.
Ms. Cavaco is not present. Mr. Costello?
Yes.
Mr. Hutchinson is not present. Mr. Waller?
Yes.
Mr. Levin is not present. Mr. Pizer?
Yes.
Ms. Botrain is not present. Mr. Zuccarello? Rob?
Come back to me. Come back to me, Dave.
I vote yes, Mr. Zuccarello.
Oh, I'm at the alphabet. You can't. You can't. Yeah, alphabet. No.
Thank you. And a vote of 6-1, 6 in favor and 1 against, the motion carries. 2-10-3 goes on to define what a financial interest is. It says, for the purposes of section 10 of chapter 2 of this charter, the financial interest of a representative town meeting member shall be determined pursuant to the interpretation of the, and I can't see the rest. I thought maybe you'd be faster than me, Rob. No.
There you
All right, shall be.
Right? Yeah, 10-3.
Yep, you're good. Shall be determined pursuant to the interpretation of the term financial interest by the State Ethics Commission and applicable reported appellate court decisions, which are hereby incorporated by reference. The financial interest of a department shall be defined as any particular warrant article and related motions or votes which specifically refer to said department. Steve?
If we wanted to address the issue that we have eliminated from section 1 and just indicate that the final financial interest of a town employee shall include any particular warrant article and related motions which specifically relate to said town employees department. We could do that. I think that
It's just,
otherwise it just makes sense to eliminate that last sentence.
yeah, I feel like it's like we're reviving 2-10-1.
I know,
So,
and that's right. Otherwise, my suggestion would be just to delete the last sentence.
To support that, I don't know that we know what the word department means. No, I'm serious. It has changed
Yes,
since this charter was written.
Yeah.
And the town clerk's office is not a department. It is a division.
right,
And it is a division. So basically what it's saying is that if this mythical town clerk, who's also a town meeting member, couldn't vote on anything that had to do with the town manager.
right.
And that's ridiculous.
Keeping that language in there, department, and it almost goes back to employee. Now, it doesn't address my conflict of interest as a independent contractor. What's my financial interest if I'm bid on a contract or an article that I'm about to vote yes or no on?
So that's in 2-10-2.
So it addressed it back there?
Yeah, because if you have a financial interest, this defines your financial interest.
Well, no,
This
I think-
first sentence.
I think Alan is asking, what is the financial?
What is my financial interest? I'm in my particular case, over the years that I've been attending, I've abstained twice, and I've written a letter and passed a letter. If there's gonna physically be a communications tower financed by the town built,
Yep.
I've abstained, but I wanna keep my options open to bid on the job at a
Yeah.
later time. Now, if I bid on the job and win the job, that's the financial interest. I'm gonna make X number of dollars. If I'm a real estate guy and I sell the condo, that's your financial, where does it address the financial interest for all of these professionals and things like that? Where is that?
In the State Ethics Commission and appellate reported
So
decision.
it's in that,
The most recent appellate reported decision that I read actually addressed, ironically, very similar to what you just said, which made the determination that a future potential interest is considered a financial interest. Whereas the individual who was sanctioned and was challenging it had said, no, it has to be an actual current interest. And the appeals court, actually, the Supreme Judicial Court, made the determination that said that would be twisting things on its head, that we look to the legislative intent, that financial interest is specifically not defined in the records, and that's why they looked to the legislative intent and came up with that determination.
I was the chair of the Historic District Commission for 15 years. We had trouble getting an architect on the commission because it wasn't the case that the architect could say, I have an interest in that particular matter. The architect could not deal with the town at all. And it was so onerous that I won't say this out loud, and thankfully the architect is no longer alive and can't be beaten on. We just ignored it. And what we have here is basically words. And as far as I'm concerned, let's the sooner we get home, the sooner the scotch flows.
Yeah. The only piece here is, I think, since we've eliminated departments and employee references, I think Steve's right, I think we ought to eliminate the second sentence. I'll ask the committee, is there anyone who's interested in making such a motion to eliminate the second sentence, or the final sentence of 2-10-3?
I'll move that.
Mr. Pizer makes the motion. Mr. Bulletin seconds. Is there discussion on the matter? Rob, I see your hand up.
Are we making change for the sake of change sake? Because that's kind of what it feels like. We're just fooling around with words, and I think it's best, I mean, there's a motion on the floor, we're gonna vote on it, that's fine, I get it, believe me. But I'm wondering if these change just for the sake of change, think about what this is gonna do on town meeting floor when and if this ever gets there.
Oh, I know. We'll all be there. Mr. Lawler.
So to piggyback on what Rob's saying, I still think that, we've come down to the bottom line here. And we're not talking the talk. So why don't can I suggest that we bring up Steve's, and put some teeth into it? Under a different section.
Yeah.
So if it's like, so in that way, it's easier to be, take it out. And no harm, no foul, you know what I'm saying?
Let's finish this and then we can, I'll let Mr. Bolton determine if he'd like to pursue that. Is there any further discussion on this motion, which would be to eliminate the final sentence from 2-10-3? Hearing and seeing none, I'll call the roll. Mr. Bulletin?
Yes.
Mr. Hanlon?
Yes.
Ms. Cavaco is not present. Mr. Costello?
I'm gonna vote yes as well.
Mr. Hutchinson is not present. Mr. Lawler?
Yes.
Mr. Levin is not present. Mr. Pizer?
Yes.
Ms. Votrain is not present. Mr. Zuccarello?
No,
And I vote yes. In a vote of 6 in favor and 1 against, the motion carries. The other piece, I'm gonna loop things back to where we started. I'm gonna take the temperature of the room, so, by show of hands, are we interested in, implementing an enforcement provision in this part of the charter?
As a separate.
Yeah, we would do another, we would
Just
do,
completely separate.
yep,
Brief question
Yeah.
before, everything. Have we determined as a committee how we're gonna put this forward at town meeting? Are we gonna do it line item by line item? Or is it one take all, winner take all?
no, I think what we're probably gonna do, and I've started to have this conversation with, the town manager and the town council, is that we would probably group these into buckets, so like. Housekeeping items would be one thing, where we go through and we say, vote on all of the times where we capitalize the word town, just as an example. So I would group them in a bucket. Then we might group like, I don't know how I would phrase it, but, substantive changes as relates to town meeting into a bucket, substantive changes as relates to select board in a bucket. And then what we would look to do is to see where those items of contention might rise. And we would probably look to folks to request to divide, an individual part. So like if we did if we did all of chapter 2 as one bucket, and listed all of the changes that happened in that bucket, and then we get the sense that town meeting's gonna tear apart the components that address, conflict of interest. We'll look to a member to make a motion to divide that section out separate from the remainder. Does that make sense?
Yeah, and that was the reason I asked, because I'd like to pursue what Mr. Lawler's talking about, and I have no problem working up something, putting it in there. But I wanna know as a committee, at the last minute, we can pull it, or change it, so it doesn't ruin all the rest of our work for the last 18 months.
And I think as the article proponents too, we would be able to pull out individual pieces. If we're starting to hear some chatter about parts that we don't think are gonna pass, I think we can make those determinations.
All right, then, if that's the way you hope to do it, and you're waiting on the final determination from town council, is that how you gonna run it, or are you waiting for someone's advice?
Well, so we have to write all the motions.
Oh, okay.
So once we see what all the motions actually say, we'll be able to group them into buckets, and then from there, we can decide if there's anything we wanna pull out. Tim?
We're doing all this work on this section here. And it's great work, we're cleaning things up, making things make sense.
Mhm.
I just think it's prudent for us, right? To complete the job.
Mhm.
And the job is to put some teeth into this under its own section, so it's easily carved out if need be. But it really does make the whole section 2 complete.
Mhm.
That's my feeling.
So I'll ask one more time. Please raise your hand if you wanna put an enforcement mechanism into this section of the charter. We only have 2 members who have raised their hands, so I don't think that will be a fruitful conversation. I agree with you, Mr. Lawler, we ought to finish the job. But I don't think that there's appetite among this group, and I think that's indicative of what will happen at town meeting as well, so. Please know that I've noted on the record that you have requested that we pursue this, and the committee has declined to do that part of the job. Mr. Bulletin, is there anything you'd like to add to this from your proposal?
No.
Excellent, thank you. That concludes our discussion items for the evening, unless anyone has anything else to add or detract or modify from either section.
Can I make just a quick historical statement?
Sure.
Historically, town meeting is not Congress and not the state legislature. History means what happened in the past. And I forget the saying, like in financial matters, past performance does not indicate future expectations. But as a historian, I just want it understood among this group that a great deal of the reason that I have said about town meeting what I have is that it is pictured, and I think it's clear in Chesterfield and Pelham that it's a bunch of people getting together. It used to be a bunch of white guys with property getting together, but now it's a bunch of people getting together and reasoning together. I like that. And that's why I've said what I've said. And I understand the statements on the other side, but it's been a evolution happens, but it doesn't always happen fast. Thank you. But many years of historical study, I had to say that.
So noted for the record as well, Mr. Pizer. Hearing and seeing no additions, modifications, or detractions from the two items that we had on the agenda tonight, I'll move on to new business. Hearing and seeing none, old business, I do have a single item. I sent out to the committee a request to pursue the possibility of a Saturday of a Saturday marathon session. I've heard from a number of full members already that Saturdays are a non-starter for them. And because of that, I don't feel comfortable moving forward. While I do believe that we would have quorum, I think that we would be precluding members who may otherwise be occupied, whether that's professionally or personally, time with family. I want to respect that for folks. And we'll stick to the schedule as we've been pursuing on Tuesday nights. I want to thank folks for registering their opinions and for those who were available for making yourselves available. But I think we do some hard work and we do this for free for the town, so we ought to enjoy a bit of respite on Saturdays. So we won't move forward with that. Any other old business? Hearing and seeing none, unless there's objection, I will call this meeting adjourned at 7:42 PM.